Good evening, everyone. I now call the June 21st, 2023 Board of Adjustment meeting to order. Just a few small announcements. Tonight, we're going to welcome Planner Jillian Harris. She's from the Planning and Sustainability Department. Jillian will be the board staff planner for next week's meeting and will be assisting Stephanie with meeting coverage moving forward. Welcome.
Thank you. Happy to be here.
And due to the large volume of requests for June, new business items D through J are scheduled to be heard on June 27th. So if anyone is here for one of those, we're sorry, they're next week, Tuesday though. Applicants are granted 15 minutes to present their project. If you anticipate needing more time, please ask at the beginning of the presentation, and the board will consider your request. Speakers 2 for or against will get 5 minutes. Okay? All right, the first item of business is approval of the 2 sets of minutes that we have. The first one being May 16th, 2023. Anyone who'd like to speak to that?
I move that we approve the minutes of May 16th, 2023.
Is there a second? Second, thank you. Are there any comments, changes? All in favor?
Aye.
Thank you. Approval of the May 23rd, 2023 minutes.
I move that we approve the May
I
23rd.
think there's a,
One minor thing. Yep.
Jeff.
So I have it on page 10 for those minutes. At the very top sentence, it says another direct abutter in the SRA zone, but it's actually the SRB zone. That's
good
it.
catch.
Yep.
Good catch. I did not see that.
Okay. Okay.
Also, in the opening section of the minutes, there should be an I at the end of my name where it says Mr. Ross moved. It should be Mr. Rossi.
Okay, thank you. All right, if there are no other changes, a motion to approve with these changes. Yes, Mr. Mantle.
Madam Chairman, make the motion to approve the minutes for May 23rd, 2023 with the changes as indicated.
Okay, is there a second?
Seconded.
Okay, thank you. All in favor?
Aye.
Aye. Okay. All right, we're moving to old business, and just so everyone knows, ML will be sitting as our alternate the entire evening because Jody is not here tonight. A request for a one-year extension for 420 Pleasant Street is the first item of business. I don't have. Do we have an explanation? No.
It's in your packet.
Oh, I'm sorry. I didn't.
Page 37.
Yeah. I missed that. So what would people like to do? Oh, I can see this, sorry.
I move that we grant the request for
Okay.
an extension.
Is there a second to that motion to grant the request?
Second.
Okay, Mr. Miller, is there any discussion? David?
Thank you, Madam Chair. So, we used to get requests for one-year extensions all the time back when there was only a one-year time period where you had an opportunity to get a building permit to execute your variance or special exception that you were granted. They're now allowed 2 years. This applicant has gone the full 2-year time frame. They are using the pandemic as their primary reason for extending. I am going to support the motion, but I do need to say that and caution staff that I think the pandemic is starting to run its course as an excuse for not getting a project to the point where you have a building permit for it. So just something I think that we need to keep in mind as a board. Again, it used to be routine to give one-year extensions. Once the state changed the rules, the law to be 2 years, the additional 1 year for a third year was considered more of an exception rather than the rule. That's all.
Okay, yeah, thank you. All right. So,
Is any further comment necessary on my part since I made the motion, or
no, I don't think so.
I have nothing to add?
Okay. All right, then, do we have a second?
I second.
Okay, thank you, I forgot that. All in favor?
Aye.
Anybody opposed? No. Okay, then the extension is granted. The next item of business is request, item B, a request for rehearing on the appeal of 1 Rains Avenue, as ordered by the Superior Court on February 2nd, 2023. The board will determine in the first instance whether it has jurisdiction over the issues presented by Duncan McCallum, attorney for the appellants, in the January 14th, 2022 appeal of the December 16th, 2021 decision of the Planning Board for property located at 31 Rains Avenue, 203 Maplewood Avenue, and 1 Rains Avenue, which granted the following: A, site plan approval, B, wetlands conditional use permit, and C, certain other miscellaneous approvals, including an approval related to valet parking. Said properties are shown on Assessor Map 123, Lot 14, Map 123, Lot 13, Map 123, Lot 12, Map 123, Lot 10, and lie within the Character District 4 District, Downtown Overlay District, Historic District, and the North End Incentive Overlay District. So, would someone like to start this discussion? Yes.
I will move to deny the motion for rehearing, and if I get a second, I'll speak further to my motion.
I'll second
We have a second from Mr. Matz,
Sorry.
or Mr. Rossi with an I.
Yep.
Yeah.
So just to remind, I don't know, anybody who might be watching, this was a remand from the Superior Court, and I am not sure whether or not even we're allowed to do a motion for rehearing on a remand for from Superior Court. But that said, I will say that for pursuant to paragraphs 1 through 9 of the motion, they relate to Mr. Rayum's participation in the hearing. That is not a matter that I find is within the purview of the ZBA to actually weigh in on. The ZBA is a board of statutory jurisdiction, RSA 674-33, and also the administrative code of the city of Portsmouth, and that is beyond our jurisdiction. The issues raised in 1113 as to paragraphs 11 through 13 as to the participation of Mr. Pizzullo, that was something that was dealt with in the remand for Superior Court. And again, I do not find that the ZBA has jurisdiction over that kind of matter. That is something, that and the matter with respect to Mr. Rayum is something that the Superior Court will deal with if it's appropriately before them, and that I don't know. The rest of the appeal has to do with the parking. That was a matter that was on the motion was on the remand from the Superior Court. That matter was not very well, I thought, pled out when it came down from Superior Court, and I do not think it's appropriate to supplement the record at this time, given the limitations that we were given when we first looked at this. And lastly, the issue in paragraph 16 about the possible contamination of the site with hazardous waste was not something that was part of the remand from Superior Court. So therefore, I do not find that we have any need or are even allowed to hear this motion for rehearing. So I move to deny it.
The only thing I will add is that since I seconded it and I wasn't here at that particular meeting, I did familiarize myself with the facts of the matter, and I agree with the statement that was made, the statements that were made with regard to the motion.
Okay. The further discussion? Okay. Then the motion is to deny the rehearing. Okay. Ms. Geffert.
I support the motion, so yes. Oh, did you want me to comment on it?
Oh, no, just the vote.
It's a vote.
Yes, yes.
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 Yes. Mr. Mannell?
Yes.
Ms. Margison?
Yes.
Mr. Rayum?
Yes.
Mr. Rossi?
Yes.
Mr. Mattson?
Yes.
And the chair votes yes, and so the request is denied. Okay. So- The next item of business is a request for a rehearing for 170 Aldrich Road. Is there anyone who would like to speak to this? Sorry, Mr. Rain.
Yeah, thank you, Madam Chair. I will just offer my comments. I was not at this meeting. However, I did take some time to go and watch the proceedings of the board on the YouTube video that was available. That was challenging because it was broken up into two parts. So I was all excited. I found it, and I'm listening to it, and then I'm like, wait a minute. It got delayed, and then I had to try and figure out where it got picked back up again, and I did find it. So certainly there were some challenges associated with this particular case. My one thought on granting the request for the rehearing is that because of the communication issues with the applicant, they did their presentation. There seemed to be communication issues after that. There is some of that is brought up by the applicant in here. And I think really one of the key factors that seemed to turn the board's opinion about the case was a presentation by an attorney for an abutter who presented a lot of information, and the applicant never effectively had an opportunity to go and rebut that information. And I'm not sure, the applicant kind of indicates there may have been some technical issues associated with that. Certainly there was technical issues with the ability of the applicant to both hear and then participate in the meeting because of the fact that they were doing it remotely because it had been postponed into the time frame that that the meeting occurred. So I think in fairness to the applicant, I really do believe that testimony by that opposing attorney was a pretty influential discussion, and that the applicant, normally during the 2-4 or against, the applicant would have an opportunity to come back and rebut information that has been given by the opposing attorney. They either never fully availed themselves, but it does sound like that maybe they tried to, and because of the technical issues, didn't have a chance to do that. So I think in that sense, I think out of fairness, it would make sense to rehear this particular case.
Anybody else like to comment?
First of all, I want to thank you for that, because having been here, it wasn't as apparent. But I would like to add to your commentary that it may be that we should encourage the applicant to be here in person for the rehearing.
Anybody?
I guess, yeah, I would add that normally I wouldn't take granting a rehearing lightly, and by default I would almost start off as no and have to be convinced of a yes. And in this scenario, the unique situation with the remote technical difficulties, I think that falls under the category.
I would just add to that we also had questions for the applicant that we weren't able to get answers to. So I believe a rehearing is the fair thing to do.
Did the applicant have the opportunity to request postponing this until he
No,
was
there was
able to?
no, I think the answer is no. Until he was able to be here.
Yeah.
Yeah. Do you mind if
Not
I?
at all.
So in communication with staff, the applicant is always encouraged to participate in any way that they can. And in the past, we haven't had these technical issues. So that wasn't a warning that they got. Obviously, that will be moving forward. And I think, that Ms. Gefford hit it on the head that we should reconsider presentations from a virtual source.
Is there a motion? Would somebody like to move this question?
I'll make a motion to grant the rehearing.
Is there a second?
I would second.
Thank you. If there is no further discussion, I'll call for a vote. Would you like to speak to your, sorry, I'm sorry.
I don't know.
Spoke before.
I don't have anything else to add beyond what was just discussed.
I shouldn't have presupposed
Nope,
that,
yeah.
but thank you. Ms. Geffert,
I vote in favor of yes.
Mr. Mantle,
Yes.
Ms. Margerson,
Yes.
Mr. Ryan,
Yes.
Mr. Rossi,
No.
Mr. Mattson.
I'll say yes, and I just the criteria that Ms. Geffert had of, I guess, requiring them to be in person for the
Yes, sir.
rehearing. Yeah.
Yes. And the chair votes yes, so a rehearing is going to happen. And you will let him know when that can be. Okay,
Yes.
thank you. The next item D is request for rehearing on 634 Sagamore Avenue. And we have two people who are recusing on this vote. I guess I should say Mr. Rayum and Mr. Rossi, so the minutes know. Okay. Yes, Ms.
We should
Murchison.
wait for Mr. Rossi to leave. Oh. No. All right, so, I will, this is rare for me, but I will move to rehear this application. I think that our process on this was perhaps not the cleanest it could have been, but I think substantively, the reliance on Walker versus City of Manchester in terms of finding the abutting properties non-conforming was misplaced. As we discussed at the hearing, the Sagamore Court was properly zoned general apartment mobile home, and Tide Watch, although in the SRA zone, is a planned unit development because it is over 10 acres. So for those reasons, I would vote to rehear. Oh, I didn't wait for a second. There.
Is there a second? That's my, is there a second? No?
Oh.
Okay. Would someone like to make a different motion?
I guess I would just make a comment that it's an interesting note, although I haven't received any extra information regarding Walker v. City of Manchester. So I guess having that situation, I am not inclined to change my position. So I guess with that, I would make a motion to deny the rehearing.
Okay. Is there a second before Mr. Mattson speaks to his motion? To deny?
What was his motion?
To deny.
Yep.
Second.
Would you like to speak to your motion?
Yeah, I don't see any reason to grant this rehearing, and as I stated, I think, starting from a position of not granting the rehearing and then having to be convinced to grant it, by not having been convinced, I would move to deny the rehearing.
Okay. Do you have anything to add, Mr. Mann?
I will say, after reading the request, I support the motion to deny. There's a few confusing parts in here trying to single this parcel out, and it's unrelated to Tide Watch. Now, granted, Ms. Marginson said, Tide Watch is a planned unit development of 10 acres. I think that if this parcel was 10.2, we'd be dealing with the same thing. It's single residence A. As I've stated before, the density of what Tide Watch is proposing is similar to the density, of what Lester King, that 635 Maplewood, was proposing, is similar to Tide Watch. The fact that they are only 44 buildings is irrelevant because the zoning request was for a living unit. Could have been a duplex, a triplex, whatever. If the applicant came by with an application for 2 buildings with garages, that were 2 units each and copied the exact same style and floor plan from Tidewatch, we'd be doing this again. So I think our decision was proper in the first place, and I will support the motion.
Yes.
And I just wanted to quickly comment that I appreciate Vice Chair Margison's observation under the Manchester case, but I think that we were looking at the character of the area, both on one side and the other side of Sagamore, but also at the character of the current use, which is, I mean, effectively a dilapidated industrial nonconforming. And so the honoring the zoning ordinance took on a broader perspective based on the current nonconforming use. And I think that the zoning board correctly assessed the 4-unit residential development as following the spirit of the zoning ordinance. And I believe you commented, and I'm not trying to say, well, you're contradicting yourself, but rather one of the things that swayed me was that the applicant's change from 5 units to 4 made it more in keeping with the surrounding area and lot coverages in the existing zoning. So I just want to point out, I understand that how that case can be interpreted, but I do want to also say that this is a very special parcel. The current use, the non-conforming use, made our consideration slightly different than what that case presents.
I would also just add that even independent of Walker v. City of Manchester, I still see by a unique set of the combination of conditions of the property that the special combination of conditions makes an unnecessary hardship.
I'm going to support the motion, and it seemed to me that the request for rehearing relied a lot on seeing this development as overly crowded, when in fact each house is on about a half acre and they meet all of the setback requirements. And so I guess I'm feeling that we judged this correctly. Is there any further conversation? If not, I will call for a vote. A vote denies a rehearing. So a yes vote denies the rehearing. ML?
Yes.
Mr. Mantle?
Yes.
Ms. Margison?
No.
Mr. Mattson?
Yes.
And the chair votes yes. So the rehearing is
Denied.
denied. You can come back in. Okay.
I think, am I recusing myself for this one, Maplewood?
Yes,
Okay.
yes.
Yep.
All right.
Yeah.
The next item of business is the request for the Islamic Society of the Seacoast Area, ISSA owner, and Chinberg Development LLC applicant for property located at 686 Maplewood Avenue, whereas relief is needed to construct 4 duplexes and 1 single living unit to create a total of 9 living units, which requires the following. 1, variance from section 10.440, use number 1.30, to permit 4 two-family unit structures where they are not permitted. 2, variance from section 10.513 to permit 5 freestanding buildings with dwellings where not more than 1 is permitted. With dwellings where not more than 1 is permitted. 3, variance from section 10.520 to allow A, 6,975 square feet lot of area per dwelling unit where 15,000 square feet is required. And B, 47 feet of frontage where 100 feet is required. Said property is located on Assessor Map 220, Lot 9D, and lies within the Single Residence B District and Highway Noise Overlay District. Welcome.
Thank you. Good evening, Madam Chair. My name is Justin Passe. I'm a lawyer at TTC Lawyers here in town. Here tonight on behalf of the applicant, which is Chinburg Development LLC, joined by the development team to include John Shagnon from Ambit Engineering, Carla Goodnight from CJ Architects, and we have Colton Gove from Gove Real Estate Group as well. I'll do a quick introduction if it pleases the board. I'll ask John Shagnon to come up and quickly summarize the plan. I'd like to summarize the application of the law, the statutory variance criteria to the facts here. And of course, we have our team of experts to answer any questions. Before you, you should have 7 exhibits total to include Exhibit 1, which includes an aerial photo of the zoning map and a tax map, 2 ambit plans to include an existing conditions plan, a variance site plan. We have some floor plans and renderings of the proposed units from Carla Goodnight at CJ Architects, and those renderings really are the product of a few meetings that Carla and the development team had with city staff to try to incorporate the character and historic nature of the city and the area into the design. We have a landscaping plan for Exhibit 4, which depicts the buffer that we're proposing to insulate the development from surrounding properties and from 95. We have a density analysis that was conducted by the Chinburg folks, which will hit frequently, I think, throughout the analysis tonight, and certainly it was a theme of what we wrote in writing in the application. But as you noted, there are 9 units being proposed here, and what we've determined through the density analysis in Exhibit 5, which really looked at the immediate vicinity around the property on the east side of 95, and then looked at Maplewood Ave to the south and north on the west side of 95, and ultimately concluded that particularly with regards to the immediate area, the density, the lot area per dwelling unit being proposed, which is 6,975 square feet, is roughly equivalent to the density of the immediate neighborhood, which is 7,361 square feet of lot area per dwelling unit. Enclosure 6 is a traffic analysis that Ambit put together, which basically analyzes the last proposal that was before this board and which was approved, which was for a religious assembly use, which depicts that at the peak hour of that use there were 75 trips, and at the peak hour in the PM for this use there are 7 trips. We'll use that contrast to essentially articulate the impact of this development. And lastly, there is a property impact analysis from the Gove folks regarding the anticipated impact this development have on surrounding property values. So very quickly, we're talking about a uniquely large property that abuts 95 here, and it really sits as a transitional lot between the more dense business and commercial and residential areas of downtown and the less dense areas as you head west on Woodbury Avenue. It's largely unimproved, maturely vegetated right now with a buffer along the northern boundary as well as the western and southern boundaries. Is abutted to the north by 2 other properties that have duplexes on them. Those are at 64 and 74 Emery Street. And to the west by a 3-family unit at 678 Maplewood. It also abuts a commercial industrial use and 95. It's the first SRB zoned lot after the business district that encompasses much of downtown. And in our view, it really captures the transitional point from the denser areas of downtown to the less dense areas west on Maplewood. It's also unique because of its grade and topography. The elevation at the Maplewood Avenue level is 40 feet. It rises up to 60 feet to the top of a hill, essentially, before it slopes back down to surrounding properties. So John will hit the plan highlights, but we're talking about a multifamily condominium here, as you noted, Madam Chair, 2-family dwellings, 4 2-family dwelling buildings, and a single dwelling proposed. One of those units is proposed to be affordable. The dwellings are depicted in the renderings provided by Carla and her team at CJ Architects, but we're talking about single-car garages for each unit, kitchen bathroom on the 2nd floor, and a master bedroom, bathroom, and an additional bedroom on the 3rd floor of each of the units. Additional design details of the units include covered porch areas, doghouse dormers, exterior decks, hardyboard siding, and again, that proposal is really the product of consultation with the city to try to incorporate these architectural components into the design. There's a single driveway from Maplewood with a 5-foot sidewalk to accommodate pedestrian foot traffic. The project will comply with setback requirements, building coverage requirements, open space requirements, parking requirements. We have 20 spaces proposed where 14 is required under the zoning ordinance. There's a robust landscaping plan, as I've mentioned, and then also a recreational area that consists of 6,500 square feet for mostly passive recreation. We envision walking dogs and other types of passive recreation in that area. So that's the basic concept and project proposal. I will quickly turn it over to John Shagnon for him to do an overview of the plan, unless, of course, there are questions at this point from the board.
Questions yet?
Thank you, Justin. Members of the board, John Shagnon from Haley Ward. If we could go back to the plan set cover page, and I just wanted to walk you through some of the plan pages. So the cover page shows the development team and the zoning, and you can see the site on the middle of the page, left side, adjacent to a different zone on its eastern border, and then the site in the locus map in the middle shows you its proximity to Route 95 and the Maplewood Avenue corridor. And then you can kind of see glimmers of the street networks that are to the north and west and south of other lots that were bigger lots that were subdivided or into smaller lots in earlier days. This is sort of a leftover larger lot that is in a grouping of some other larger lots to the east in that other zone. If you go to the next page, it shows the existing conditions, and as Justin mentioned, it rises up from Maplewood Avenue. It's a long, skinny lot. It's constrained in that way, and there's some ledge in the top. As you go up towards the top of the hill, there's also a power line that runs across some of the lot that is a major feed from the Route 1 bypass to the downtown. You see that other lot on the north side that is a three-family. It's sort of a cutout lot. It looks like it was cut out of this lot, but it actually existed a long time ago. It wasn't recently cut out of this lot. The next page shows the proposed development. So the development concept is to run in a driveway. The lot was approved with a variance for the use as a potential mosque. That project did not go to construction, and but the site was used as a staging area for the Maplewood Avenue reconstruction project. So if you have looked at it, that's why it is predominantly gravel at this time. It was used for staging materials, and we're following that same driveway grade up and placing the units on the east side as far away from the highway as possible. There's a sidewalk plan to go up the west side of that driveway to provide pedestrian access from all the units to the sidewalk network on Maplewood Avenue. So as you come in, there'll be a flat area on the left as you come in. That area in gray is a recreational area. It's actually also serving double duty. It will provide for stormwater management. Being at the bottom of the hill, it will allow us to not increase any stormwater runoff to abutting properties. And there's a duplex unit on the left, another duplex unit, a single unit, a duplex unit, and then at the top of the hill in the extended view is the front of another duplex unit. And behind those southerly units is an area that will also provide some additional passive recreational area. The next sheet shows the renderings of the proposed unit, which CG Architects worked closely with city staff to develop a look that would fit in with the historic nature of the neighborhood, provide what is needed as far as the massing of the units and the layout to be productive. There's a one-car garage on the first or lower level, and then the second parking space in front at the street side. So each unit has 2 spaces immediate to it. And then the next page shows the single unit rendering. And I think that's it for the set. I think that's the last. No, I'm sorry, there's landscape plans. So landscape design has been provided to show some buffering to the adjacent properties. And the site will go through the technical review process. There'll be meetings there where we'll discuss more about landscaping, utilities, site drainage, and other features. If there's no questions for me at this time, I'll turn it back over to Justin.
Just as a point of clarification to make sure I understand the layout. So the parking area at the back of the lot encroaches into the easement, is that correct?
Yes.
And that'll be paved and that's
Yes.
a paved parking area?
Yeah, so that will require a joint use agreement with Public Service.
Which
That's
you
an allowed
already
use.
which you already have or do not have?
That will be part of the approvals yet to come. It's not an unusual joint use for a power line. In fact, we can go back to that sheet. It's of some benefit to Public Service because it's going to provide better access to their corridor. The things that they would be concerned about have to do with snow plowing, and there's plenty of room to provide for that, not under the power line. Does that answer the question?
Thank you, yes.
Okay. Yep.
Okay,
Thank you.
Mr. Shagnon.
So, Madam Chair, at this point, my inclination would be to do a summary overview of the statutory criteria as they apply to the project, if that pleases the board.
Yes, we would
Okay.
welcome that. Thank you.
So, as you noted at the top, Madam Chair, we're here on several variances, which I've categorized into variances that pertain essentially to the use table and the dimensional table in the zoning ordinances. First, we need relief to have 4 two-family dwellings where two-family dwellings are not permitted in the district. We need relief for single standalone, 5 standalone buildings where no more than 1 freestanding dwelling is permitted in the district. The aforementioned density relief here to have 9 dwellings which have 6,975 square feet of lot area where 15,000 square feet of lot area is required in the district. And then the frontage relief variance. So, as the board is aware, the Supreme Court has indicated that the zoning boards of adjustment should analyze the first 2 variance criteria together, and they are whether or not the variances will be contrary to the public interest and whether or not the spirit of the ordinance will be observed. And the question here really is whether or not the variances will unduly and in a marked degree conflict with the ordinance such that they violate the basic tenets of the zoning objectives. There are 2 tests from the case law which have been borne out. The first is whether or not the variance will alter the essential character of the neighborhood, and the second is whether or not the variance will threaten the public health and safety. So here, as I've said, the variance is derived from the table of uses and the table of dimensional standards. The objective of these ordinances and really of the SRB district in general is to provide medium density and aesthetically consistent development in the area between the downtown and the commercial gateway corridor along Woodbury Avenue. They really pertain to the regulating of the aesthetic in this area. So the foundational point here is that we don't see a marked conflict between the proposal and the point of the zoning ordinances because we see the project as being consistent with the aesthetic and the nature of the neighborhood that surrounds the property. And that's really because of the unique configuration of the property that we've talked about. It's because of its physical characteristics, but it's also because of the built environment around the property. And it's because of those things the project really is consistent with the neighborhood. More specifically, the property abuts 3 different properties which have either 2-family or multifamily properties on them. I've mentioned them, but they are 64 and 74 Emery Street, which both have 2 families, which are abutting the property to the north, and 678 Maplewood Ave, which is a 3-family unit, which directly abuts the property to the west along Maplewood. The density in the immediate neighborhood, the 14 SRB lots to the east of 95, is 7,361 square feet of lot area per dwelling unit, and we're proposing 6,975 square of lot area per dwelling unit. So it's a roughly equivalent density of what is immediately surrounding the property. There's also less traffic than what the previous proposal for the property was. As I mentioned, Exhibit 6 is a report from John Shagnan's office, which depicts that at the peak hour of the formal proposal, which was approved through the ZBA and also through the planning board, there were 75 trips, where the peak hour of this development will have 7 trips. The project also complements the city's master planning efforts, which, as this board knows, are extensive, particularly by adding the one affordable unit that is certainly beneficial and consistent with the master planning. We're providing additional housing, additional tax revenue, which we also see as benefits for the project. So to summarize these first 2 zoning criteria, there's no market conflict because the project is really consistent with the goals of the underlying zoning ordinance to provide medium density and to have aesthetically consistent development in this area. It also satisfies the case law because the project's going to be consistent with the essential character of the neighborhood, and because particularly the impact from a traffic perspective is significantly less than that which was previously proposed and approved. There's no public health or safety impacts as well. The third criteria is whether or not substantial justice is done by granting the variance. The guiding test here, as the board knows, is that any loss to the individual that's not outweighed by gain to the general public is an injustice. At bottom, there's really got to be a gain to the general public from denying the requested variance that outweighs the loss or detriment to the applicant from its denial. So we're really talking about a balancing of the interests here. We don't think that the public gains anything by denying the requested variance. The property has been the site of several development proposals over the year. The last proposal, as you know, had more of a traffic impact than what we are proposing. We see this as a reasonable transition from the downtown area to the less dense areas along Maplewood Avenue towards Woodbury Ave. We see the density as being roughly equivalent to the immediate area around it. So ultimately, the impact is de minimis. We're providing an affordable unit, and we're creating additional tax revenue for the city, all of which are public benefits and which err on the side of granting the variance. Of course, if the variances are denied, the property will not be developed. There will be no additional affordable unit, no additional tax revenue, and no reasonable use of what is otherwise a unique property, essentially squished up against Route 95. The fourth criteria is whether or not the proposal and the variance will diminish the surrounding property values. We see that criteria as being satisfied. The development, as we've said, is consistent with the surrounding area. It's certainly consistent with its 3 immediate abutters, which are either 2-family or multifamily. It's otherwise surrounded by a commercial industrial use and Route 95. Certainly the GOV analysis, which is enclosure 7 before you, is consistent with these findings. If anything, we see this project as increasing the value of the property, which will have a corresponding effect of increasing the value of surrounding properties. So last but not least, the fifth criteria is that literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. The test here is that unnecessary hardship means that owing to special conditions of the property that distinguish it from other properties in the area, there's no fair and substantial relationship between the general public purpose of the ordinance in question and its application to the property in question. So really, there are 3 tests. Are there special conditions? Does denying the variances advance the purpose of the ordinances? And is the use reasonable? So briefly turning to those 3 questions, certainly there are special conditions of this property. The property is substantially larger than other residential lots in the area within the SRB district. It has a unique configuration with a large swath along Route 95, only 47 feet of frontage. Its topography is unique as its elevation rises significantly from Maplewood Ave up to the top of the hill. It is the first lot to the east of 95 that's zoned SRB before you get to 95. And it has this unique capacity to appropriately accommodate and reasonably accommodate the proposal here. So for those reasons, we would suggest the lot is unique compared to those that it surrounds. Second, the question is, are the purposes of the underlying ordinances advanced by applying them to this property and denying the application? We would say, of course, that the answer to that is no. These variances, again, derive from the table of uses and the table of dimensional requirements. The inherent purposes of these ordinance and of the SRB district itself is to encourage and facilitate medium density in an aesthetically consistent manner. We think that the property and the project does that for the reasons we've outlined. Certainly, denying the variances won't advance the purpose of the ordinance, because the opposite of true, as we've laid out. The last question is whether or not the use is reasonable. We would suggest it is, in light of the properties and the uses that surround it and the existing built conditions. So that's the analysis. Happy to answer any questions that the board may have.
Are there questions? Mr. Ram?
Yes, thank you, Madam Chair. On page 2 of your presentation, it's page 110 on our package. So under project proposal, I just want to validate, you are saying this will be developed into a multifamily condominium. So the intent is that each of these units will be for sale and that the owners will be part of a condominium association for however many units there are.
That's correct.
Okay. Your second, just a couple sentences down, you talk about that one of the proposed dwelling units, as you also discussed, will be considered affordable as defined in the city's zoning ordinance. So typically, there's also a time frame associated with that. What is your expectation for the time frame for that affordable unit, and how do you anticipate it being legally documented?
Well, so the application itself is a notice to the city that we propose an affordable unit, and I think traditionally that issue comes up when you get to site plan review and it's a multifamily process that you're going through. This was really a preliminary hurdle. As I was talking to the GO folks before I got up here, we haven't even designated which of these units will be the affordable unit. So I think, assuming that relief is obtained here, we'll put a more formal proposal together regarding the specific nature of the affordable proposal, and then implicate the statute and reference that in our filings with the planning board.
Okay, I mean, you brought it up in your arguments both orally and in writing, so I was just curious if you had any early thoughts on what you were anticipating if you were moving forward. Mostly because it does, I think in my mind, speak to our substantial justice criteria of the sort of that balancing test between what is the public getting out of this versus what you're asking for.
So certainly the thought was, by referencing, I think I hung a footnote that referenced the specific definition of affordable in the city's zoning ordinance, with the idea that certainly the applicant would be happy with a condition of approval that required that at least one unit be affordable in a manner consistent with the city's ordinance.
Yeah, I mean, normally by the time they get to the planning board, there is some discussion of like a 30-year time frame or perhaps longer based off of considerations at that point. I just didn't know if you had any preliminary thoughts on it.
I have not had those discussions with the applicant.
On page 3, which is page 111 of our packet, about the middle of the paragraph, middle of the page, you say the project incorporates a 6,500 square foot recreation area, which area will serve as an amenity to residents of the neighborhood. So I'm trying to understand, is that your intent that it'll be open to the general public?
Well, so I would imagine it would be common area to the condominium that would be utilized by owners of condominiums. Certainly through the planning process, I assume that the TRC can make a recommendation for there to be some type of public easement or something such that other members of the public could get access to that facility. But for now, I think the proposal is for it to be utilized by condominium owners.
Okay, yeah, in my mind, something different than what you're stating there with, residents of the neighborhood, in my mind, is a more broad term with the expectation that
fair enough.
The general public could come and use it. So, kind of moving down quite a ways to your charts that you have, and give me a second because it takes a second for my iPad to catch up here. So you have your table on, it's your enclosure 5, it's on page 130 of our package. So this is where you make the argument regarding the square foot per dwelling unit. So you're asking for 9 units pretty consistently, and the drawings, a couple pages earlier shows, four virtually identical buildings with the duplex units, and then kind of this one additional one that you're putting in there that's kind of this tall, skinny little building that looks a little odd. At least you're putting it in the middle, so I suppose it sort of negates some of the fact that it's kind of very different than the others. But your argument is that at 6,975 square feet per dwelling unit is just, in your argument, just a little bit below the 7,361 square feet of the immediate neighborhood. I think you called it a negligible difference. I did the calculations, about 5%. I don't know if I call 5% negligible. But I'm curious, if you were reduced down to 8 units, the calculation there is 7,847 square foot per dwelling unit, which puts you kind of right in the right in the general expanded neighborhood number that you have of 7,995 square feet per unit. And in addition is just a little bit above the 7,500 square foot per dwelling unit, which is for GRA, which is, you're in SRB now, but the closest other residential area is all GRA, which would be a 7,500 square foot. Sure. So I'm just curious for what is your thinking that you need that ninth unit? What is the difference there, and what would be the negative impacts if this board felt that 8 units were more appropriate?
Well, I mean, certainly I'd have to consult my client and get the details. I know that the project it's gone through several iterations. I think that the project went from a 10-unit proposal to a 9-unit proposal through initial correspondence with the city, and then there's a discussion, obviously, and an offer to make one of the units affordable. So at some point you get down to the business analysis, which I know is not particularly germane to the ZBA and their determinations, but certainly relevant from a developer's perspective. And I see your point. Certainly when you look at particularly the lots that are right around this property, we're talking about 2 families on lots with densities that are less than what we're proposing, and the 3-family at 678 Maplewood, which is significantly less. So from that context, it really is consistent with what's immediately around it. But I see your point, and if it's I can't tell you whether or not it changes the analysis wholesale from the developer's perspective if it was to be reduced to 8 units. But certainly that's the proposal before the board.
It's the affordable or silver, but we can do 8 all just regular and get rid of the affordable. But we thought throwing in affordable would be worth it.
I'm sorry, would you come to the mic if you're going to introduce yourself?
So, Colton Gove with the Gove Group. It was the affordable unit that got us down there. So, I mean, we could get rid of the affordable unit and be at that 7,800, but we figured the affordable unit was more important to everybody.
Okay.
Are you done?
That's all I have.
Okay, are there any other questions? Mr. Mantle?
You made the point that this development would be in character with the rest of the neighborhood, and pointing to the 1, 2, 3, 4, 5 multi-units, correct?
I think of the 14 in the immediate vicinity, there were 4 total that had multifamily or 2-family.
Well, I'm looking at your chart. Immediate neighborhood, there's 5 multi-units.
Correct.
Okay. Out of those, 1, 2, 3, 4, 5, 6 extra units, how many are 2,100 square feet?
I don't have that information.
Okay. Because what you're proposing, I understand it, and it looks pretty good, but what you're comparing the multi-units in these things with your use. But your use is, every one of your units is 2,100 plus square feet. Why would you compare it to, say, an ADU or an apartment that's 400 square feet and saying, well, it's the same?
Well,
that's what I'm trying to understand.
I appreciate that. I mean, what we're actually comparing is
The fact that they have multi-units on it.
Well, no, we're comparing density. We're comparing the number of units to the size of the lots, and we're suggesting that our proposal with 9 units is roughly equivalent to the density, that regardless of the size of the lot or the number of units on that lot, to the density of the lots in the neighborhood around it.
Density of living units.
Correct.
Okay.
Anything else? No. Mr. Mattson? Oh, goodness, Mr. Rossi.
It's okay.
AKA Mr. Ross.
Yes, I go by many names.
Tom?
How does your density, what always perplexes me about these density calculations is that when you have multiple units per structure versus 1 unit per structure, or 2 versus 3, or things like that, how does this change if you look at it in terms of the number of structures on the property as opposed to the number of units? Because as I look around the immediate area, I really don't see anything with that dense of an allocation or, that dense of a use of multiple structures on a similar sized property.
Yeah, I think your point, Mr. Rossi, goes to the uniqueness of the property. You've got a 1.44 acre parcel which has this odd configuration. And so when you contrast the available upland on that property and the ability to develop it in a manner which makes economic sense against the idea of, for example, trying to propose a subdivision road and make lot sizes which are more consistent, it becomes a question of feasibility and viability. And what you're left with is a condominium proposal where if you were to draw lot lines around the proposed condominiums, they would probably look a lot similar, more similar to the boxes and the lots along Maplewood that we've highlighted. So it's a novel approach to developing the property that avoids tons of impervious surface in the form of a big road that the city wants to accept, and it avoids a subdivision process. So I guess, I don't know if that answers your question, but to me it really goes to the uniqueness of the property. You've got this tiny frontage and you've got this big upland area, and it can accommodate reasonably a density which is, as we've said, roughly equivalent to the immediate area, which is what we focused on. Admittedly, we focused on the dwelling unit per lot area calculation because it's the most reasonable approach, I think, to comparing the density of these properties.
Yeah, well, see, the thing was when you are seeking variances from both the number of dwelling units per building and the number of square feet per dwelling unit, it gets a little bit hard to compare that on an apples-to-apples basis with surrounding properties. And I'm not sure that's the right way to look at density in this particular case. But anyway, thank you.
Are there any other questions? Ms. Margerson?
So I think my question perhaps may be more of a comment, and perhaps you can respond to it. So I think the most problematic part of the application is the 2-family dwelling units, which are not allowed in the SRB zone, and the 5 freestanding buildings. And then the density relief, you have a parcel that's about 1.5 acres. An argument could be made that you may have hardship because of the small frontage from the street for putting 3 single-family dwellings on the property. Could you respond to that?
Well, so the hardship, the basis and the law behind the hardship analysis goes to whether or not there are unique circumstances of the property and whether or not applying the specific ordinances in question to the property because of the unique circumstances accomplishes the goal of the ordinance. So we have an ordinance that prohibits, on some level, multiple buildings. It prohibits 2 families. And so the question, and we'll go to density next, the question in those 2 contexts is whether or not applying the ordinance in this case accomplishes the prohibition on those types of uses that's in the zoning ordinance. And the answer, I think, has to be no. If there are duplexes that surround this property, which there are, if there are multi-family units that surround this property, which there are, then the purpose of the ordinance is not being satisfied by applying it to this property. And the same goes for the density analysis. The density analysis is 15,000 square feet per dwelling unit. Well, hardly any properties in this area have 15,000 square feet per dwelling unit. And so the question is, you have to develop some process of comparing and contrasting our proposal against what is surrounding it. And to us, the most reasonable way to do that is to take the number of units on each lot and divide that into the lot area, because that's how density is calculated. Lot area per dwelling unit. So that's where we get the number, the 6975, and the rough equivalents to what we've articulated as the immediate surrounding area, which are these yellow blocks. So the question again, the zoning ordinance says you have to have 15,000 square feet per dwelling area on this lot. But all around it, there are properties which don't satisfy that. So the question is, does applying that to this property accomplish the goal of the ordinance? Is it somehow protecting the essential character of the neighborhood? Is it somehow protecting the public health and safety? And because of the existing built condition that surrounds this property, we think that the conclusion has to be no. It's not compromising the essential character. It's not compromising the public health. So that was the analysis we undertook.
Okay, thank you. Just one follow-up.
Yeah, please, go ahead.
So you talked about subdividing the property, and I guess I'll have to defer to city staff on this. My knowledge of subdivision is that, so you have a property that roughly could contain 3 single-family dwellings, but you would need enough street frontage to access all 3 of those dwellings. So when you talked about that in terms of you talked about somehow subdividing this property even with the 47-foot front line. Can you explain that a little bit more?
I don't want to get over my skis, and John can certainly address this as well, but I think you're correct. At some level, there either needs to be a private road proposal or a condominium development or relief to accommodate a city road, so that the lots interior to the property have frontage in a manner that's consistent with the zoning ordinance, which we haven't, I don't know if we've done the analysis. Certainly, I think it would require a lot of relief.
Okay.
Do you want to hear from Mr. Shagnon?
Sure.
If we can go to the next page. And I don't know if I'm answering your question or not, so the lot that exists now is shaped oddly, and it is, this is obviously a road, but it's a limited access highway, so you're not going to be accessing the property from there. And the nearest street networks are one lot away. But something I'm noticing is if you take a look at the size of this block, so to speak, and you take a look at the size of this block here, if this was properly configured in a way that could be subdivided easily, it would be an equivalent area of property. And if you look at the analysis of, if you go back a page, that block is contained up here, and there are, if you add them up, there are 8 or 9 units in that block. I don't know if that answers your question, but by today's standards, you couldn't subdivide it in the same way, but in the standards of the way that part of town was subdivided in the past, it sort of would have worked out to 9 lots if somebody had chosen to do it in the manner that it was done back then with the lot sizes.
I'm going to try this question.
Yeah.
Are you saying that those houses in the amber color up there, 8 or 9 of them,
Yeah.
would fit into the square footage of your odd-shaped lot, if it
believe-
were not so oddly shaped?
Right, I believe they would.
Okay, I just
Yeah,
wanted to
yeah.
make sure that's,
That's kind of what I'm trying to say.
okay. I'm sure you said it, I just wanted to clarify. Okay. Are there other questions for Mr. Shagnon while he's up here? Okay, thank you.
Okay.
Do you have more that you want to add?
No, Madam Chair, unless there are other questions.
Questions?
I have 2 questions. The first is, your analysis tonight and in the packet talked about conforming to SRB as you're looking at it, but you didn't address the noise overlay. Now, I'm not trying to replicate the planning board's role in terms of a conditional use permit there, but I would like you to address the public interest, particularly creating dense housing units that are close to a highway.
So
That's the first question, and I'll say the second question. I'd like you, and it may be John, needs to address parking on the lot, because it's clear that you've got a garage and maybe a space outside the garage, but just, and 4 additional spaces, and I'd like you to address how that addresses the dense development you've got,
Sure.
if you wouldn't mind.
Well, certainly, I appreciate the first question. I'll definitely punt on the second to John. My statement at the top is that I want to be careful. I mean, the innovative land use control statute, which is at the root of putting the noise issue into the purview of the planning board in the conditional use process, is intentional, and I don't want to conflate that process with the process before this board regarding the relief that we're requesting, which doesn't have to do with noise. But I will say, and Carla will be able to elaborate, certainly the design that has already gone into these renderings and concepts incorporate and account for the fact that there will have to be additional insulation and that they will have to comply with additional design criteria and standards to make sure that they can meet the criteria outlined in the conditional use process that they'll have to go through before the planning board.
Yeah, that's about all I needed,
Yeah.
because we're not trying to do that
Sure.
here. But I just wanted to make sure it was addressed. 'cause
I
you did
appreciate the
mention
question.
Parking was the second part of the
Right,
question.
Mr. Shagnon.
Speaking to the second question, so if we go back to the site plan, the design of the road and as it comes down, and intentionally, these driveways are at least 20 feet from the curb line. So each unit has a garage space in the unit, and then there's room to park a car comfortably outside. And so it is a stacked situation. You were allowed to stack in residential. The unit at the end has the garage unit, but just to provide for the access to this area, there isn't a space out here. There's 2 spaces here for that second parking space for that unit, and then 1 space per 5 is the guest parking requirement, so there are 2 guest parking spaces. And then as you do look at the ordinance, as it's currently configured, any unit over 750 square feet is only required to provide 1.3. So this really provides 2 per unit with 2 guest parking spaces. Does that answer?
It does, and I appreciate you putting that on the record. So I visited the site, and unlike something that had street frontage that was accessible, there is no ability to park other than on the property, just to be clear.
Yes, and as we go through the process, there may be, if things come up, there are some other spaces that could be dedicated to additional parking if the Technical Advisory Committee feels that there should be more.
Yeah, it's really just, and again, I'm addressing public interest and just making sure I understand your intention. Thank you.
Okay, thank you.
Okay. Is there anybody in the public who would like to speak in favor of this project? Anyone in favor? Is there anyone in the public who would like to speak in opposition to the proposal? Is there anyone who would like to speak to, for, or against? Last call. To, for, or against. Okay. The public hearing is closed. So, I see a lot of perplexed faces. What was it? Okay, I wasn't sure.
I can start us off, Madam Chair. I don't think I'm perplexed. I'm most of the way on what's being asked for here, but let me go through what I'm seeing, because I think some of the questions from some of the other board members, I'm not sure they're seeing things quite the way I am. So really this comes down to, this is a single residence B lot. Is a single residence an appropriate use for the lot? I think this board, prior incarnations of this board on 2 separate occasions said, no, really, this lot is very large. It's butted up against the Interstate 95. It has like a setback aspect to it. And on 2 different occasions for 2 different types of religious uses, this board said, yep, we agree that a single residence use is not really the best and proper use of this, this particular property. Then it comes down to, I know there's some concern about the duplexes. So we definitely don't, in general, want duplexes in a single residence district. I think I'm comfortable with it here. If it was lined up on the street where, your streetscape is single family home, single family home, single family home, and suddenly you have this row of duplex homes that sort of break up the pattern of the neighborhood, I would be more concerned about it. But what we're really asking for here is something that is as has been pointed out, both for pro and con, remote, it's up on a hill. It's really not going to be visible to most passersby. I think people on Interstate 95 would probably get a better view of these homes than anyone who's going up and down on Maplewood Avenue. So in that sense, I find that less of an issue. And I'm kind of seeing this property is in some ways misplaced in the SRB district. If you look at the immediate surrounding properties, so there is the small property that's up against Maplewood that contains the what is actually a 3-unit building. It's an old, circa late 1800s, a 2-story with a mansard roof, which is pretty rare, by the way. Most of the time you have a 3-story if you're going to have a mansard roof. But that's got 3 units in it. And then on the backside, the 2 abutting properties that actually go out to Emery Street also were subdivided, came before this board, and they also have duplexes on them as well. So it's really surrounded by business and or other duplex uses, or really in one case, a 3-unit use. To me, it's more akin to the next closest zone, which is the general residence A, which, as I mentioned, if you look at the plan provided by the staff on page 105, you kind of look at the zoning there. Yeah, this area is SRB, but again, as I mentioned, that there's sort of duplexes butting up against it, a business on one side, and then that small little lot that's up against Maplewood. There's another section of SRB, but really the majority of the neighborhood going further down the street is GRA. GRA does allow duplexes, and it has the 7,500 square foot per dwelling unit density requirement. So in some senses, I feel more comfortable with kind of putting this particular parcel into that sort of envelope of saying, hey, if this was zoned GRA rather than SRB, which in some ways could be more appropriate for its use, then it would be mostly there in terms of what's allowed. And then it comes down to the last question is this density question, and it's the one that I'm struggling with the most. Again, I would feel really comfortable with it if it was in the 7,500 square foot. It's about 500 square feet less than that with that 9th unit. Naturally, the applicant has said, well, if I lose the 9th unit, the one you're going to lose is the affordable housing unit. A natural response to the query. What's the balancing test there between the benefit to the applicant versus the benefit to the public of, allowing that greater density? I guess that's the last question that I'm really struggling with this application. So those are my thoughts.
Thank you. Anybody else?
I'll take a stab at it. I'm concerned that how the narrative of SRB has changed. The bottom of page 5. Specific purpose of SRB district is to, quote, provide areas for single-family dwellings at low to medium densities, approximately 1 to 3 dwelling units per acre. And then if we skip ahead to page 11, it's medium density. And I'm like, okay, what happened to low? The number of units bothers me. If we're going to your original thing on page 5, 1 to 3, you're asking for 9. That's triple. You're comparing it with other properties in the neighborhood that have 1 to 3 units as being similar to the neighborhood. Okay, fine. Then where's the hardship then? 1.5 acres. Yeah, easily 3 houses. You might even get more on there with variances. But 9, I understand what they're trying to do. 9 is just, for me, it's a little bit too much. Add in the fact that when Mr. Riom suggested knocking down the single, and their response was, well, we can get rid of the affordable unit. And I'm like, okay, you know, for all intents and purposes, okay, if we deny it, we're not going to get an affordable unit. And I'm like, no, it doesn't work that way. Well, you know, as far as, well, if you don't grant us this, we're not going to do that. You know, if we come back and it's smaller, we're not going to have any of that. So that's where I'm at right now.
I would like to add that I don't place much value on the affordable unit in this case. This is a really difficult location for residential use. I cannot see these units commanding any kind of a premium in the market. You're right up against a highway. You're on the other side, you're next to a motorcycle shop, and you're by high-tension power lines in the back. It's a really unsightly and frankly unpleasant location. So I don't think that offering an affordable unit is really much of anything in this case.
I think in Portsmouth now, you could build this in the middle of 95, and you would get a lot of money for it.
I don't think so.
just don't think a bad location exists in this city at that point, so I would.
On that,
maybe
I
not.
beg to differ.
But I've been amazed at the prices
Well,
that houses are
I agree
getting.
with you there, but
Yeah.
this is really quite a thing.
Okay.
So I will not be supporting this application. I'm just going to be very candid and upfront there. And I think the ask is turning this lot into something more than like the GRA, GRB, and GRC zone, and that is very moderate to high density. I think this is high density for this lot. I think if you look at the exhibit that we have up now, the GRA and GRB is not really contiguous to this lot. It's contiguous to the SRB lot across the street. So I don't think that we can, you know, it's definitely not next to this lot. In terms of the previous variances and special exceptions that were granted for this lot, the places of religious assembly are as allowed by special exception for the SRB zone, and those were the special exceptions that were given. The variance was for the 47 feet of street frontage, which if they do not get that variance, they will not be able to build on this lot, even if it's an SRB. I don't think the applicant has demonstrated hardship for the two-family dwellings and the amount of dwellings that are on the lot. I'm not saying, I mean, I like this project, I'll be honest, I do. But we have to look at hardship, and I could probably find a hardship given the street frontage and the size of the lot for 3 single-family dwellings, but I cannot find it for the two-family dwelling relief and the density relief. I mean, this is taking it down. This is a large lot. It's about 1.5 acres, a little under 1.5 acres. You know, you're probably looking at, you could get probably 3 lots in there for the SRB calculation. And this brings us down to, again, what is below even what is required, what is allowed under GRA, GRB, and GRC. So for those reasons, I will not be supporting the application. However, I would support the frontage relief because if that is denied, they will not be able to build on this lot.
Do you want to make that a motion?
I don't know how the board is feeling. So.
I don't see any other comments.
I generally concur with what you're saying. So.
With somebody. I'll just talk while you're all thinking about making a motion. This is difficult. I agree with Ms. Margison. It's a great project. I think the buildings are wonderful.
Madam Chairman,
Yes,
can I make a motion to approve just one of the asks?
you can when I finish my sentence.
Oh, I'm sorry.
And if one followed the rules here, it would be an exceptionally large lot, and a foolishly large lot for a one home in this part of town. But I guess I have to agree with Ms. Margison that I'm not seeing the hardship. I know this is a unique piece of property for a couple of reasons. But the uniqueness of it, I don't think, is really driving the way in which you're using it, in my mind. I don't think that one accounts for the other. So, okay, Mr. Mann.
Well, I was going to make a motion because, as Ms. Margison said, I mean, the 47-foot frontage is going to be problematic regardless. And whether it's one house or 160. So I will make the motion to approve item 3.B, 47-foot frontage where 100 is required.
Okay, is there a second? To break it up? To divide the request?
A second, yes.
Yes, you'll second? Okay, do you want to?
Okay, so this is fairly straightforward. Approving that would not be contrary to the public interests. It's frontage for a lot that is big enough for cars, but it's not big enough for zoning. It's an access point for an 1.5 acre lot. Granting the variance would observe the spirit of the ordinance. Yes, it would. You have to have access to your property. Granting the variance would do substantial justice. Again, same thing. You have to have access to your property. You only have 47 feet. So granting the variance would not diminish the values of the surrounding properties. It will have no effect on the surrounding properties. And literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. Well, the hardship is the fact that this lot is the remnants of subdivisions that went in, that took effect when 95 was built. The original size of this lot went across the street and into Fairview, Edmonds, and further down. And this whole parcel was one huge parcel back in the day. I believe the family name was Moretti. That owned all this parcels, much of it. And because of that, it got cut up, and this little sliver with a 47-foot frontage was left over. Not granting this would result in a hardship. That's just my thought process here.
Do you have anything to add?
My second would just say that the special conditions of this property are that it has the just 47 feet of street frontage. So therefore, owing to those special conditions, it cannot be used reasonably, and also there is not a fair and substantial relationship between the purposes of the zoning ordinance and its application to this property.
Thank you.
I just want to remind you that in front of you are 2 letters from the butters who are opposed to the project. And in fact, the backyard, that land belonged to Helen Stern, and it was her backyard at 678 Maplewood, so. Okay. Is there any further discussion on the motion to approve a variance for the frontage? Mr. Vane?
Yeah, I mean, I'll be supporting the motion. I don't think it does the applicant much good, but I guess if it gives them a little piece of something, they can go build a single-family home. That's about it. So all they can do on the property. But I'm okay with it.
Or they could come back with a different development plan
come
that
back
addresses
with
some of the
another.
concerns that were expressed here.
Sure. I'm not gonna-
So, okay. So remember, it is for this one portion. Ms. Gepper.
Yes.
Mr. Mannel.
Yes.
Ms. Margison.
Yes.
Mr. Graham.
Yes.
And Mr. Rossi.
Yes.
And the chair votes yes as well. So it really looks good, but
It does.
the hardship just.
But we need to.
Point of order, Madam
Take
Chair?
another
Yeah.
motion.
We still have all kinds of
I know,
requests.
I
Okay.
know. I'm sorry. You're right. You're right. You're right.
We need to do something with them.
Yes. We need to do something with you. Now you can get on to the land. Okay. The next item of business is the rest of this proposal.
So I would move that we deny the variances for, to construct 4 duplexes and 1 single living unit to create a total of 9 living units. The variance is from section 10.440, use 1.30, to permit 4 two-family unit structures where they are not permitted, and the variance from section 10.513 to permit 5 freestanding buildings with 3 freestanding buildings with dwellings where not more than 1 is permitted, and also the variance from section 10.520 to allow a 6,975 square feet of lot area per dwelling unit where 15,000 square feet is required. And if I get a second, this time I will wait for my second, I will say why.
Okay. Mr. Mannel has seconded you.
Okay, so I believe that these variances requests, and I think that the applicant did a good job of actually sort of summarizing them for us, I'm sorry to say. The 2-family dwelling relief, the 1 dwelling per lot, and the density relief are contrary to the public interest and the spirit of the ordinance, and those are sections 10.233.21 and 10.233.22. The purpose and intent of the single residence B district is to have 1 freestanding dwelling unit on the property, and also not to have any 2-family dwellings on the subject lot. And this is in direct and marked is directly contrary to that purpose and intent. Also, the density relief, the lot is big, and this would bring the lot size down to 6,975, where 15,000 square feet of lot area per dwelling unit is required. That is also directly contrary to the purpose and intent of the single residence B district, which is to have 15,000 square feet of lot. I know we only need 1 provision to deny the variance, but I will speak to the hardship, which is little enforcement of the provisions of the ordinance will result in unnecessary hardship, and the property has special conditions that distinguish it from other properties in the area. And owing to these special conditions, there is no fair and substantial relationship between the general public purpose of the ordinance and the specific application of that property. The proposed use is a reasonable one. I do not think that I find that the variance application fails this test in that the applicant did not demonstrate hardship for having a 2-family dwelling and more than 1 dwelling unit per lot, and for the density relief. And so that is my motion to deny.
Does the second have anything to add?
I have nothing to add. Very good.
Is there further discussion before we vote? Mr. Graham?
Thank you, Madam Chair. I will be supporting this motion, although I think I'm more there than some of the other board members. I don't have any problem with the fact that those are duplex homes. I think it's an appropriate use. I do think Mr. Rossi has a decent point in that it's not the most ideal lot for residential uses. I think that from a usefulness standpoint, that the duplexes actually make a lot of sense in terms of affordability for the types of units that could end up there. I don't think a single family homes are necessarily the right use for that, or calling for that just because it's in the SRB district when it's really going to be hidden from the streetscape really makes a lot of sense in my mind. But I do think that the density ask is just a little over what is acceptable. So with that, I'll support the motion, but that's really where my heartburn generates from, for the record.
Yeah.
Thank you.
I recognize that as well, but I guess it's the combo of the small lot size and the type of buildings that are going up. The combo is just not letting me do this. So, any further discussion before we vote? Okay. So a yes vote denies the
Approve the
project.
denial.
Ms. Gifford?
Yes.
Mr. Mantle?
Yes.
Ms. Margerson?
Yes.
Mr. Graham?
Yes.
Mr. Rossi?
Yes.
And the chair votes yes. So. It's hard.
Very.
When you have a good architect, it's okay.
Here's Jeffrey.
Okay. So we have finally arrived at new business this evening. A, the request of Charles Silva Jr. and Margaret Moran, owners, for property located at 434 Marcy Street, whereas relief is needed to construct an addition to the rear of the existing structure, remove the existing shed, and construct a new shed, which requires the following. 1, variance from section 10.521 to allow A, 8-foot left yard setback where 10 feet is required, and B, 43% building coverage where 30 is allowed. 2, variance from section 10.321 to allow a nonconforming building or structure to be extended, reconstructed, or enlarged without conforming to the requirements of the ordinance. 3, variance from section 10.573.20 to allow A, 1-foot rear yard where 11 is required, and B, 1-foot rear side yard where 11 feet is required. Said property is located on Assessor Map 102, Lot 41, and lies within the General Residence B and Historic District. Welcome.
Evening. Ann Whitney, I'm the architect for the project. I have the most immediate abutters, the two on South Street and two on South Street, one on Marcy, have signed off on.
Thank you.
What we're proposing here is there's an existing one-story shed roof addition off the back of the house with a bay. And they would like to add some space on the second floor and into the attic. And so we're proposing to build, not add any foundation in that area, but just build over that and bring it up to the existing roof line. And in addition, do a small entry addition. The existing shed, which is bigger than the one we're proposing, is sort of bumps into that space and is really tight to the existing addition. If we go to, and then so we're moving that shed over fairly close to the property line. Actually, I'm calling for 1.5 feet, not just 1 feet. That's big enough to be able to maintain, get in behind there. You go to the next page, so go through. The lower photo there shows just, the view from South Street, and then the upper one is a very slight little view through to the back there. So this addition, that side there. We actually go back. I'm sorry, keep going, I guess. The next sheet. Yeah, that, the elevation on the right there, the existing addition is in line with that left side setback. So we're basically going to be bumping that up with a 2'4" cantilever, and then matching the eave line of the existing house and bringing it up to the peak, and setting back a dormer over 3 feet back from the edge, so to add a little more headroom in that on the attic space. On that same page, shows the cross section of the existing house, and that bay is sort of one of the favorite parts of their house. So we're going to recreate that bay, and then there'll be a little bit of an overhang roof over the entry steps, and then behind that, there's a small mudroom addition to create an entrance to the back of the residence. It's pretty much the primary residence to the house. So then if we go back, 3 of 4, that's the rear elevation where you see the existing dormer on the left side, and then this addition that bumps up into the attic roof line. So the proposed second floor and attic addition will be built over the existing rear one-story L with a 2-foot-4 cantilever. And the small mudrooms, one-story rear addition will provide mudroom space, and an existing bay will be slightly enlarged and rebuilt. The existing 160-foot shed in the left side yard will be removed, and a new 8x14, 112-foot shed will be located at the right side. These changes will result in just a net 30 square feet increase in building coverage. Locating the shed close to the rear and right side will allow 2 cars to still park in the driveway and maximize the use of the yard. We're going to be kind of gaining that whole side of the yard where the existing larger shed is. And the existing residence is non-conforming to building coverage at 40.9%, and on the front, rear, and left side setbacks. The proposed additions will continue the nonconformity at the rear and left side yards. These variants are not contrary to the public interest in that many properties in this neighborhood are nonconforming to those 2 building areas and setbacks. The addition is primarily built over the existing footprint. The rear of this property is minimally visible from both Marcy and South Street. Actually, that one picture, yeah, the lower one there, I had to actually go into 28 South Street all the way into the end of their driveway to be able to take a picture of the back of the house. It was a little hard because there are lots of trees there now, so it's hard to get photographs. Variances are consistent with the spirit of the ordinance and allow this small footprint change that will add needed living space without adversely affecting the abutters in the neighborhood. All 3 immediate abutters are in support and have reviewed the plans. Substantial justice will be done as the variances will allow expansion of the living space with minimal changes to the building coverage and setback. And these variances will not diminish the value of surrounding properties. I have done a work session with the HDC, and there were a couple of issues, but for the most part, they were in support of this. The special condition of this property is the nonconformity of the existing residence and lot. The lot at 2,700 square feet is just over half the required 5,000 square feet in this district. This nonconformity, as I said before, is shared with the majority of the properties in this area. The minimal setback relief and low increase is in keeping with the neighborhood, and again, is supported by the immediate abutters. Are there any questions?
Any questions? Yes.
Thank you, Madam Chair. So I think looking at your page 1 of 4, it's page 145 on our
Yep.
package. I think you kind of talked to why your client wants to move the shed to the opposite side of the lot. I guess, I know you're like 1.5 feet. The city staff, I'm presuming you guys shortened that down to 1 foot, sort of like a, rounding, make sure that,
Okay.
that we don't go over. Going to page 3 of 4, so page 147 in our packet, that picture that you mentioned, Kim, from the driveway of 28 South Street. So moving, it does appear like there's a fairly tall fence that goes around the back side of the
Yeah, and
property.
actually, I meant to mention that one of the letters submitted, the people at 28 South Street. Right now, there's basically a 6-foot fence with a little bit of a curve between the sections. And there's a small section where the shed is going to be in that current fence that's down around 4 feet for some reason. And then as you proceed south, the actual existing shed, it becomes the fence on that side. So in agreement with the abutter at 28, we're going to be replacing, filling in that fence and keeping it all at the 6-foot height.
Okay. And then I guess goes to my question would be, how tall is the shed that you're proposing? That's the one dimension that we don't have.
I have that.
And as you're
Oh,
thinking.
shoot, it's about 11 feet. I put the HDC in, and I meant to bring that sketch to this meeting. We're doing the HDC in July, and I had not drawn the shed at that point. It's a small 512 pitch, and it's around 11 feet tall. So it's going to stick up above the fence.
Okay, so it's like a gable roof to
A
it.
small gable roof on the 8-foot.
But really, the neighbor's probably going to see more roof than anything else.
Yeah, they're going to see some siding and
Little
some
bit of
roof.
siding.
Yep. And
Okay.
I showed them the HDC drawings when I reviewed this with them on the site last week.
And I guess I would let city staff weigh in on it, but I'm not sure if making that a 6-foot tall fence, if that's causes any complications from the zoning ordinance and our fencing issues that we're looking at in a couple cases from now, so.
I think 6 feet is our maximum, that we can't go above 6 feet. And the
Yeah.
current fence there now, that before you have the curved things between the posts, the current fence on all the property here is 6 feet at that high point. So we'd just be matching existing.
Okay, nothing further. Thank you.
Anything else? I
That's it?
guess that's it.
Okay, thank you.
And I will have to ask if there is anyone in the public who would like to speak in favor of this petition. Is there anyone in the public who would like to speak in opposition to this petition? Is there anyone who would like to speak to, for, or against? Okay. The public hearing is closed. So, what would you like to do?
I'll make a motion to approve.
Thank you. Is there a second to Mr. Mattson's motion?
I'll second.
Thanks, Mr. Mantle. Okay.
Okay. Granting the variance would not be contrary to the public interest. The proposed use doesn't conflict with the explicit or implicit purpose of the ordinance, and it won't alter the essential character of the neighborhood, threaten public health, safety, or welfare, or otherwise injure public rights. And that also addresses the number 2, granting the variance would observe the spirit of the ordinance. It's a very small, modest addition that is minimally visible from the street and entirely within the character of the neighborhood, and additionally it will be going before the HDC. Granting the variance would do substantial justice. In this situation, the benefit to the applicant is not outweighed by any harm to the general public or to other individuals. Again, it's not really visible from the street, and the improvements to this property would benefit the applicants at no harm to others. And granting the variance would not diminish the values of surrounding properties, and there's no suggestion that this would be the case. So that's fine. And literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. The property has special conditions that distinguish it from other properties in the area, and owing to these special conditions, a fair and substantial relationship does not exist between the general public purposes of the ordinance provision and the specific application of that provision to the property, and the proposed use is a reasonable one. So working backwards, this is a reasonable proposed use. Is still just a single-family residence, and this is a small, undersized lot, basically half the size of what's permitted in an already dense, one of the denser zones, and the purpose of preserving air, light, and privacy are preserved with this very modest change to the structure. And yeah.
Anything to add?
Yeah, I'll just add, I mean, because of where the property is, it's in the south end. Nothing is conforming down there. And the request, except for the shed, is small. You know, the shed is large, but at the same time, you're getting rid of the other shed, which is a trade-off. That doesn't bother me whatsoever, especially now that you can, have a more use of the property. But I will support the motion.
I will just say that I'm not going to be supporting the motion, and it is the shed. I think that it brings the right and rear yard setbacks really way out of conformance. And I don't know why a smaller shed couldn't have been put on the existing footprint.
Any other discussion? Then, the motion is to approve. Ms. Geffert?
Yes.
Mr. Mantle?
Yes.
Ms. Margison?
No.
Mr. Rayum?
Yes.
Mr. Rossi?
Yes.
Mr. Mattson?
Yes.
And the chair votes yes.
Can we take a break?
Yes, how about a quick 10-minute break? Thank you. We are back on.
You're back.
I'm going to read first what we're going to
Okey-doke.
discuss, but you may hang. Okay. Hey.
And you're cold too.
Freezing.
The request of David Hugh Mason and Lisa Ann Mason, owners for property located at 239 Cass Street, whereas relief is needed to demolish single-story addition on the rear of the primary structure, construct a two-story rear addition to the primary structure, and demolish and enlarge existing garage, which requires the following. Variance from section 10.521 to allow A, 1 foot right yard where 10 is required for the primary structure. B, 3 foot left yard where 10 is required for the accessory structure. C, 4 foot rear yard where 20 is required for the accessory structure. D, 37% building coverage where 30 is allowed on the lot. Said property is located on Assessor Map 147, Lot 4, and lies within the general residency district. Hi.
Good evening. My name is Amy Dutton. I'm here to represent the last two standing people, sitting people, David and Lisa Mason. Just as an overview, which you did a beautiful job, just add on to that a little bit. David and Lisa bought the house in 2018. It has been rented and it has been this lovely shade of green and black. So I think it's time to update the house and get it a little bit more usable. The back addition, which what you can see inside where the original house was, the back addition was somewhat, it's not, it doesn't have a full foundation that goes across, so, and that's only single story. So our proposal is to tear down the existing addition and build a two-story addition on the exact same footprint, and get a full second floor in that structure. And then, as you mentioned, we will be tearing down the existing garage, and might have been a Model T that fit in there as a garage because it's more like a shed kind of thing, and it's intermingled with a big tree. So we would like to make that a usable, larger one-car garage with an extension. We'll be pulling those corners of the garage. Right now, they sit 2 feet and 1 foot from the property line, so we're trying to pull it away from the property line. So in addressing the 5 criteria, number 1, the variance will not be contrary to public interest. Cass Street, as we're seeing, is slowly renovating, and so we'll just be joining that crowd. The addition is primarily built on the existing footprint. We're just enlarging the garage, stepping it away from the property lines. Number 2, the spirit of the ordinance will be observed. The lot size in the home have very few options. The 1 foot setback on the right side. The existing addition, if you drove by, has this funny bow to it in the kitchen. The foundation does as well. I don't know why. So it probably goes to 0 setback, and we're straightening out that wall. And this will add much, much needed floor space on the second floor. And it's hard to say that it won't impact the neighbors because you're still 1 foot away from your property line, but that is not our intention. They have a very friendly relationship. Number 3, the substantial justice will be done. The existing home is already non-conforming with the setbacks, as I mentioned, and we are not increasing any livable square footage with our proposal of lot coverage. Number 4, the values of the surrounding properties will not be diminished. The neighborhood is a lovely mix of historic homes, and most of them are New Englanders and multifamilies. So this is just staying in the spirit of the neighborhood. Most of those properties especially on their block, on their side of the block, have the same exact restrictions that are going to apply, especially those 3 are built probably the same year. And then lastly, number 5, literal enforcement of the provisions of the ordinance would result in hardship. We are proposing that we create a more conforming project, although we are not able to meet all the setbacks, regardless of the effort due to the existing conditions. With the house sitting so close to the property line on the right side, we are trying to provide parking inside the garage, and then I believe we still got 3 parking spaces in lineally parked in the driveway. They don't really, on-street parking is very difficult right there. We tried to make the garage as was our hardest part of this project, because we will need to navigate in that garage and out of the garage, but they don't have we won't have attic storage, we won't have basement storage, except for, because we are going to finish the basement as best as we can, given the water table. So for outside, things like garbage and whatnot, that is the use of the garage and a car. And the front steps, as you saw, are right on the sidewalk. So there's our lovely hardships. I'm sure you have questions.
Any questions?
Yes.
Thank you, Madam Chair. So looking at your, hold on again, it takes a second for my iPad to kind of catch up with some of these more detailed drawings. Apologize. Yeah, looking at your sheet A14, it's our page 170 in our packet. So, this is currently a 1.5-story New Englander with a 1-story extension on the back, as shown in the existing east elevation. However, the topography, and from the photos that I can see this happening as well, the topography in that area does slope downwards. Is that correct?
Correct, yep.
Yeah. So you're proposing to, in that sort of descending topography, get a full 2 stories as opposed to continuing the 1.5-story roof line, sort of at the area where you're going to, feel height even more. You're asking for a lot more than what is not only currently existing there, but really exists with the rest of the home. And I'm curious, when you were looking at the design, was there any contemplation towards trying to meet your client's goals with continuing the 1.5-story roof line and using some selective dormering, particularly on the side away from the neighbor, so that it's less impactful overall with considering the 1-foot setback?
Yeah, a couple of things came into play. We have right around 3 feet 9 on the knee walls, so we would need to dormer. We would need to do an addition and then dormer it. We're trying to not hit that 50% rule, so we're trying to not impact the existing structure the least amount as possible. Are you?
Could you explain the 50% rule?
Yeah.
What you mean by that?
So if we were to impact, if we were to take anything 50% or more, then we have to comply to code 100%. So if we don't, then and the building department will give us a percentage of what we do have to comply to. So this complies, my guess is that we'll have to, this is about 30%. So that means like we won't have to take everything up to the current 2008 building code. Meaning, like we can improve the staircase, but we don't have to bring it all the way up to a full new staircase. Does that make sense? A full code staircase.
Yeah, I guess I'm a little bit at a loss to understand why this more substantial structure that you're proposing is less impactful than a 1.5-story roof line.
Because we can't get the living square footage out of the existing house, we would have to dormer it out. So if we dormer out the existing house, then we're touching that roof, it's expensive, and we're not gaining anything.
Okay, so your client is seeking a certain amount of additional square footage, but if your client were willing to settle for less square footage, additional square footage, you could still meet your goal of not exceeding the 50%, and continue the roof line and not expand as high vertically. Would that be true? This is stemming from your client's desires.
Absolutely, yes. The reason why I'm wondering about that is hitting code in the bathrooms. Because that's what we've been up against with the existing bathroom, is everything is sort of pushed towards the middle because we need 6'8" at every fixture. So we can't, the second floor is under 2008 building code, and anything that we touch, we have to hit that code.
Yeah, so just take a look at your floor plan sheet A8, which is page 164 in our plans. I mean, so currently you're actually kind of swapping the bathroom over from the 1 foot setback side over to the driveway side, and then adding the new primary bath at, about 16 feet by 8 feet. Decent size. In that new extension. I mean, I understand we're getting the full second story, helps meet those objectives, but obviously we have a compromise here of, what's your client want versus what's fair to the neighbors in terms of this new structure that is built 1 foot from the property line.
Yes.
Okay. No additional questions. Thank you.
Mr. Mattson?
Yes, I have 2 questions. One is, if you weren't changing the garage, the only variance you would need is the right yard setback. Is that true?
The existing, Stephanie knows this better than I do, the existing garage sits 1 foot and 2 feet from the property lines, and those would still be non-conforming.
Yeah, so it would be the expansion of a non-conforming structure.
Yeah, if we just, I guess, the house itself doesn't comply either because the front sits only 5 feet from the front.
Okay, well, that's actually okay, but if you weren't modifying the garage, it's the primary structure setbacks that are in question, right? Not the...
It's both, I believe.
Okay.
Let me just double check.
Okay, well, she's checking.
I believe it is as well.
Variance for the garage. It's their expansion. But
And
they're increasing the side by a foot and the rear by,
No, but that's what I'm saying is if they weren't modifying the garage's side yard setback doesn't matter.
Right, it would be grandfathered in essence.
Yes, okay.
yeah.
And then related to that, if you weren't modifying the garage, the only thing you would need is the right yard setback. Could you clarify again how you're actually, how you're gaining the 1 foot setback, even though the foundation is there?
Because the existing, let me just see if there's a picture in that. I think there is a picture. You can see it on the right side.
The bowed
It's
foundation?
bowed out and it bows out like
And
a
you're
foot.
removing that part for the...
We're just straightening it out.
Okay,
yeah.
okay.
Yep.
Okay. Okay, thank you.
Mr. Manno?
If I'm understanding this correctly, the building coverage going from 30% to 37%, since the addition you're building is in the same footprint, is strictly the garage.
Yes.
Thank you.
Okay, are there any other questions?
I thought that you and Steph were discussing.
We were, but I'm not sure that it's important to them. The rear,
I would just add that the legal description is fine, but when I was writing my report and putting in the existing and proposed conditions, the rear yard for the primary structure is in red, and it should not be
It need
bolded
not
and in
be.
red. It's just the garage that needs relief in that respect.
Okay.
So this is
And
good.
and similarly for the right yard, the garage doesn't need relief.
Right.
For the right yard, correct.
Okay, so there's a little more red than we need.
Yes.
They're asking for less
Just
than our charge.
So just to be
red.
clear,
I went a little crazy with the red, I apologize.
Yes.
so just to be clear, it's the
She had a
left yard
Sharpie.
garage setback, the rear yard garage setback, and the building coverage percentage are the only actual variances needed.
And the right yard
The
primary.
right yard for the primary
The
structure.
primary
The right yard
structure.
for the primary, got it, yes,
Right.
correct.
And, yes, and some of these are because the house has always been there. It's not
Right,
that.
got it.
This
Okay.
redesign is
okay.
changing it.
And just a clarification, we are not above the height
No.
limit for this zone.
No
That's
variance
correct.
is needed for height.
Correct. Just clarify.
No, that's good.
So I just, because I didn't exactly hear on, all the way over on that side of the board. As I read this, the right yard, we need, there needs to be relief for the primary structure, but not the garage.
From the right, yes,
Okay,
correct,
and then the left yard, it's just for the garage.
correct.
And then for the rear yard, it's just for the garage and the building coverage.
Right.
So, okay,
Right.
so,
That's about half of what the red would lead us to.
yeah. Steph has a thing for red.
Do you have a question? Yes.
I do. I think I share some of Mr. Ram's concerns about the addition on the back, in that as I see that street, that would be the only one with that kind of addition on the back. I recognize that that still does meet zoning, but I do have a little bit of concerns about the character of the neighborhood, given the extension on the back. But I'm not really sure that there's any basis to, for that in this application, to be honest, for that concern.
I think what we're trying to do is get them the square footage that they're requiring and also watching budget. And so it's our intention to use a truss roof. So we do have an 8-foot high wall, traditional built. It's, you know, and it gets them a normal ceiling height, which there isn't a lot of on the second floor.
And I do recognize that the original structure is being preserved which I know this is not the historic district, but this is an 1880 house, correct?
Yeah.
And I'd also like to say that massing is behind the street portion. So we're not seeing it taken all the way to the street, and you do have a rear yard.
Are there other questions for the petitioner at this point?
I would just like, if it's true, may I? So you're saying that your client would experience some hardship in the absence of being able to take the addition up to the height you're proposing?
Well, yes, because they would get
That's fine.
far less square footage on the second floor.
In the same footprint?
Yes.
Okay, thank you.
Okay. Thank you.
That's it. Thank you very much.
Is there anyone in the public who would like to speak to this petition? Is there anyone in the public who would like to speak in opposition to this petition? Is there anyone who would like to speak to, for, or against this petition? Okay. If not, public hearing is closed.
I would like to make a motion to approve the application as presented and advertised.
Okay, is there a second? Second. Thank you.
Okay, I guess I have to do some work. In terms of 10.2, 3321, and 2.2, this does observe the spirit of the ordinance, and there would be no loss to the public interest by allowing an extension to the rear of the home. 10.2, 3323, granting the variance would do substantial justice. There's no loss to the community or
to the town in general that would outweigh the loss to the applicant if the variance were to be denied. And granting the variance would not diminish the values of surrounding properties. As is always the case, abutters were notified, had the opportunity to express opinions about if there were any concerns about massing or the impact on their properties. No such concerns were expressed. I do not think that there is any evidence presented to us to indicate that this particular set of variances would impact the surrounding properties. And then the hardship criterion in 10.233.25, I will note that the existing conditions on the lot are with a 1-foot clearance to the right side lot line for the primary structure. And therefore, any change to the structure to bring it up to contemporary standards for livability would require a variance. And that is a special condition of this property. It already exists with essentially no lot line clearance, just 1 foot. And this does not diminish that clearance. In fact, it increases it from 0 feet to 1 feet. So in a sense, it brings it closer into compliance. And the same is true for the variances related to the garage and the setbacks. They are either within the requirements or they increase or decrease the amount of noncompliance. And I think that the current location of the garage then is a special condition that allows the new design to be less noncompliant than the current condition. So on that basis, I recommend approval of the variances and the application as presented.
Thank you. Do you have anything to add, Ms. Smith?
No, thank you.
Is there any discussion before we put this up? Yes, Mr. Ram.
Thank you, Madam Chair. I will not be supporting this motion. I don't find, this is quite a big ask of being 1 foot off the property line. If you look at the photos, it's essentially indistinguishable between the neighbor's driveway and where this house is. Yeah, okay, I agree that the existing 1.5-story house is 1 feet off. There's currently a 1-story addition on the back end that, yeah, bows out a little bit. I'm not convinced it's a 0-foot lot line, but bows out a little tiny bit, and then the applicant is correcting that with this proposal. But going up a whole nother story when you're a 1.5-story house, in my mind, is asking, well, yeah, it's away from the streetscape, although I'm still going to be very obvious. I think this is not a very deep house, so it's still going to be visible from the streetscape. But more importantly, it's really back to that 1 foot lot line. And the light and air, and really the spirit of the ordinance is to try and prevent that imposition that on a property that's that close to your property, going up by, an amount that's quite a bit more than what the existing house is. Half a story, it's put in about 5+ feet, 5.25 feet or so, that it's going to be taller. So rather than if they just extended the roof line. So with that, I can't support this. The garage I'm fine with. The overall coverage I think is not unreasonable, but I just think that 1 foot property line they're asking for more than what's really necessary to meet the fundamental objectives of having a larger house. Maybe not everything that you wanted to have, but I still think you can get a decent result with some clever dormering, especially on the side towards their own driveway.
Okay, thank you. Any for Mr. Mann?
I will agree with Mr. Riom, but from a different perspective. I have no problem with the house. I do have a problem with the garage, simply because it's driving 3 out of the 4 variances, if not, 3 out of the 4 requests. And if it was already there and it was going to be rehab, I wouldn't have an objection to it. But you're demoing the garage. And in my mind, you have a clean slate. Now, you want not to conform to the zoning? Fine. But it better be a lot less non-conforming. Here, you're only going down by a foot for a bigger garage, which is driving the building coverage. Now, granted, it's a small lot, so any small addition is going to drive the building coverage. But I would expect to see, since you're demoing and starting from a clean slate, I would want to see more conformity to the zoning, as outrageous the zoning may be from anybody's perspective, but that's just my thought.
Are there any other comments? All right. Yes.
Sorry, and just quickly to address Mr. Mantle's concerns, I kind of share a little bit of it, but I do think that the overall height of the garage, just a little tiny bit higher than what is there. They're moving it away from the property line somewhat. Really, the additional imposition is on the applicant's own property, not really on that of its neighbors by moving it. And yeah, it's going to be bigger, but it's really taking up their backyard for the most part. So because of the fact that the height is essentially the same, a little bit higher, but not a lot, I think that the light and air imposition on the neighbors is probably actually a little bit better overall. So in that sense, I was okay with the garage.
I'm going to support the motion because I realize that this goes up in height, but that doesn't need a variance. And in fact, the fact that it's a little taller keeps the windows out of looking into the neighbors' windows. And the streetscape will remain for people walking down the street, essentially the same, who are not going to see the height difference. So and there's barely anything you can do on this property that doesn't need a variance anyway. So, okay. So a vote yes is a vote to approve. Ms. Geffert?
Yes?
Mr. Mantle?
Yes.
Ms. Margison?
No.
Mr. Mattson?
Yes.
Mr. Rossi?
Yes.
Mr. Rayum?
No.
And the chair votes yes. So you are approved.
I sold you on the garage.
Phew.
You convinced me.
You too. Okay, so that is it for this evening.
No,
there's
don't we
one
have a
more.
No,
fence?
there's, I'm so sorry, I didn't,
We
I
have-
wondered if this
They're not
is-
here.
Yeah, so we
I
have
meant to
one more
ask you
order
an
of
hour ago.
business, but I'm assuming Ms. Okula is not here.
I was going to ask if he was calling in, and when you didn't say anything.
I have not heard from her
Okay.
at all.
I move that we postpone this item of business until the next meeting.
Second.
Is there a second?
So just for clarification, is that to our next meeting 1 week from today, or just under 1 week, or to our next monthly meeting?
Next monthly meeting.
Monthly.
Do you mind just reading it into the,
Not
reading
at
the,
all, I was just going to.
yeah, read it into the record,
suggest
just to
that.
be
Let me-
safe.
Make it 8.
Request of Danielle Akula, Dennis Akula, and Irenia Okula, owners for property located at 2 Sewell Road, whereas relief is needed to install a 6-foot fence where along the front of the property, which requires a variance from section 10.515.13 to allow a 6-foot fence where 4 feet is allowed. Said property is located on Assessor Map 170, Lot 22, and lies within the Single Residence B district. Since there is no one here to speak to this tonight, there has been a motion to postpone
To postpone to the next monthly meeting.
to our July
Correct.
meeting. And there has
Second?
been a second. So, all in favor?
Aye.
All opposed? No. Okay. So you will contact me and see what the story is.
I will.
Madam Chairman?
Yes,
Motion to adjourn?
second?
Second.
Yes. Yes. All in favor?
Aye.
Okay.